Hello, good morning, good afternoon, good evening, depending on wherever you are joining us from today. On behalf of the American Society of International Law, International Courts and Tribunals Interest Group, my colleague Chad Farrell and I welcome you all to this panel discussion entitled The Role of International Courts and Tribunals Amidst the Conflict in Ukraine, Avenues for Justice and Peace. If you are not yet a member of our interest group, please do consider joining us and getting involved in some of the exciting events that we organize on a regular basis. The title of Volodymyr Zelensky's speech in The Hague, delivered just the day before yesterday, was, and I quote, "No peace without justice for Ukraine." And indeed, these words have shaped the position and actions that have been taken by the Ukrainian government since the beginning of the Russian aggression in 2014 and its escalation in 2022. The conflict in Ukraine is a rather unique case study of a state that, while being a victim of ongoing aggression, while the active hostilities are still underway, seeks to peacefully settle a variety of disputes arising out of the same broader factual pattern, and therefore mobilizing different multilateral institutions for that purpose. The disputes pending before international courts and tribunals have arisen in the context of the Russian aggression against the sovereignty, territorial integrity, and political independence of Ukraine, beginning in February 2014 with the annexation of Crimea and the subsequent creation of the two separatist republics in the eastern part of Ukraine, which were recognized by the Russian Federation on the 21st of February 2022 as independent states, namely just 3 days prior to the large-scale beginning of the Russian invasion of Ukraine. Most of these legal disputes are limited in scope and subject to specific dispute settlement procedures. Now, as the International Court of Justice has consistently held in its jurisprudence, and I quote, "One situation may contain disputes which relate to more than one body of law and which are subject to different dispute settlement procedures." Indeed, there are dozens of cases pending both between Ukraine and Russia and between private parties and Ukraine. The purpose of this event is to inquire whether and to what extent these dispute settlement proceedings are likely to result in judgments that will not only settle the disputes in question and thus bring justice, but also, and more importantly perhaps, bring us a step closer to the restoration of peace between the two states. It is trite that judges are expected to settle disputes based on law, but to what extent can they entirely ignore the surrounding context and the direct or indirect impacts that they may have on their legal assessment? Can we expect that the resolution of any of the pending disputes, either individually or collectively, will bring us closer to the restoration of peace? These are some of the questions that we will discuss during this event, and we will hear from leading experts on these topics and different dispute settlement mechanisms. A word on the scope of the event. While much of the discourse about the conflict in Ukraine among academics and in the media focuses on the international criminal justice as a response to the Russian aggression, as well as crimes against humanity and war crimes alleged to have been committed in Ukraine, this event will solely focus on the state responsibility of the Russian Federation under international law, as that is essentially what is at stake in most of the disputes that we will be discussing here. And finally, before giving the floor to our distinguished panelists, a word on the way in which the discussion will follow. Each speaker will have 7 minutes to briefly introduce the disputes that are pending before a given dispute settlement mechanism. Chad will then moderate a Q&A session, following which I will take care of communicating and posing the questions from the audience. And I strongly encourage you to ask questions throughout the entirety of the event by using the Q&A option in the Zoom. And you can also, if you wish, pose your question anonymously, but do not forget to tick the relevant box for that purpose. I now have the pleasure to finally introduce our distinguished speakers. First, we will kick off the event with Juliet McIntyre, who is lecturer at the University of South Australia and an expert on the procedure before the International Court of Justice, having recently published, for instance, an extensive piece on intervention with a particular focus on the proceedings brought by Ukraine against the Russian Federation before the ICJ under Article 9 of the Genocide Convention, which is entitled Procedural Values in the Intervention Procedure at the International Court of Justice. We will then continue with Gayan Nurijnyan, a Ukrainian lawyer and lecturer at the Arctic University of Norway and Kyiv Mohila Academy. She has written extensively, including on human rights law specifically, and has previously worked at the European Court of Human Rights. We will continue our discussion in the first round of our panel with Vitaly Pohoretsky, a Ukrainian lawyer and counsel at the Advisory Center on the WTO law in Geneva. Vitaly holds a doctorate in international law and has worked previously in private practice at the WTO Secretariat on Dispute Settlement and with the Ukrainian government. He is the author of the book Freedom of Transit and Access to Gas Pipeline Networks under the WTO law, published by Cambridge University Press. We will then have Sebastian Wuschka, who is counsel with Luther Law Firm in Hamburg, Germany, specializing in investment treaty arbitration. He is the co-author of The Role of International Investment Law in Armed Conflicts, Disputed Territories, and Frozen Conflicts, published by Brill in 2020. Last but not the least, we will have Professor Nilofer Oral, who is a professor at the National University of Singapore and member of the International Law Commission, as well as co-chair of the study group on sea level rise in relation to international law. Nilofer is at the moment in Geneva, so we are particularly grateful for taking the time to join us. Nilofer has recently written, in fact, an insightful piece on the two arbitrations conducted under Annex 7, this piece is entitled Ukraine, the Russian Federation Navigating Conflict Over Sovereignty under UNCLOS, published with International Law Studies in 2022. So as you can see, we have a wonderful group of experts who are joining us both with the hat of an academics primarily, some primarily with a hat of practitioners, but all have direct expertise with the dispute settlement mechanism that they will discuss. So without further ado, I would like to warmly welcome you and to thank you for your presence. And I would like to give the floor to Juliet for the first round of around 7 minutes to present. Thank you.
Thank you, Vlad, for that very generous introduction. And greetings, everyone, from beautiful Ghana country in Australia. So I'm going to be looking at the case which the International Court of Justice has titled Allegations of Genocide. It's a case which Ukraine brought against Russia on the 27th of February last year. So 3 days after the full-scale invasion sort of kicked off. This case is interesting because it sits alongside the armed conflict. But what it actually addresses is the justification that was given by Russia for the invasion. So in its application, Ukraine says the Russian Federation has claimed that acts of genocide have occurred in the Luhansk and Donetsk oblasts, and it's undertaken military and other actions against Ukraine with the express purpose of preventing and punishing such alleged acts of genocide. Now, as most of us, I'm sure, are familiar, Article 1 of the Genocide Convention obliges states to prevent and punish genocide if it is occurring. So I'm going to run through some of the procedural history of the case and then say a few things about what I think is interesting about it. There was an urgent provisional measures hearing on the 7th of March last year. Russia did not appear in this hearing. They issued a document which they sent to the court, but it wasn't an official pleading, in which they basically said, these proceedings are beneath us, we don't think they have any legal value, and they just declined to appear at all. The court, in record time, on the 16th of March, ordered Russia to immediately suspend all military action in Ukraine. The court said that it was profoundly concerned about the use of force in Ukraine, and that Ukraine had a plausible right not to be subjected to military operations for the purpose of preventing and or punishing genocide. And obviously, Russia has blatantly ignored this order. After that, Ukraine filed its memorial on the 1st of July last year, and Russia has since altered its stance of non-appearance, which is itself quite interesting. It's filed preliminary objections in October last year. We haven't seen those. We don't know actually what's been said yet. And then Ukraine was to have filed its reply to those objections in February this year, which we assume has happened. The other interesting part of this case is the interventions, which Vlad sort of mentioned in his introduction. So the European Union has furnished the court with some what's called relevant information pursuant to Article 34 of the court statute. That's probably to be expected. The unexpected part is that we have 33 individual states across 32 separate intervention declarations who have submitted a document purportedly offering their interpretation of the Genocide Convention, but more realistically, coming in support of Ukraine and offering a form of collective condemnation of Russia's conduct. So what happened is that these started filing in around about July. Latvia was the first one, and then a number of European and Western states, Australia, the United States, and others have in quick succession filed all of these intervention declarations. The court did something completely unprecedented, which is in December said, right, here's a deadline. You have to submit all of them by the 15th because we're getting sick of this constant rolling influx of documentation. So it's not impossible that more interventions will come in, but it seems unlikely. States don't tend to like to annoy the court on these procedural matters. So what are the two things that are interesting about these interventions? Well, the first is the possibility of Russia objecting to. I'll just post in the chat if you don't mind. Hopefully this works. No, it's not working. I was going to post Article 63 from the ICJ statute for anyone who's not familiar with it. But what Article 63 does is it allows for states that are party to a multilateral treaty to intervene in a case where that multilateral treaty is up for interpretation, basically. And the purpose of this article is to allow states to offer their own interpretation of the treaty. The idea when it was drafted being, of course, that states are the owners of their treaty, the drafters of the treaty in the court would be greatly assisted by being able to hear their views and reach, a sort of global interpretation, if you will. So this form of intervention is meant to be a right of states, but there is the possibility of objecting to the admissibility of these interventions, partly on the ground that there's only one time previously where states have sought to intervene in a case before the court had even established jurisdiction, and that was in the infamous Nicaragua case. In that case, El Salvador's declaration was rejected on the basis that it was premature for coming at this jurisdictional stage. What's interesting here is that the reason the states have intervened is in order to encourage the court to take the case. It's hard to say, really, that from day one, jurisdiction in this case was done and dusted, was really, really clear. Article 9 of the Genocide Convention is very broad, and it does cover things like the alleged fulfillment of the convention. But of course, we're much more used to seeing the types of claims which are you are committing an act of genocide and you need to stop, not this sort of negative declaration claim which Ukraine is bringing, which is saying there is no genocide occurring here. Russia's claims about genocide are entirely false. So that being the case, this sort of creative version of this rather creative basis of jurisdiction that Ukraine is relying on is very clever. But all of the states have said Article 9 allows this. Article 9 is broad enough to cover this form of declaratory judgment. Article 9 allows you to deal with non-violation complaints as well as violation complaints. So all of the interventions are there in order to assist the court to establish jurisdiction. So it's obviously been seen as quite this big hurdle for Ukraine, and hopefully the outcome will be that, hopefully, but also I think realistically, the court's going to find it very difficult to resist that amount of state pressure in terms of the submissions. When you have, unanimous views across the 33 states saying that this is the interpretation of Article 9, it's going to be very hard for the court to go against that. So that's the first interesting point. Why are these interventions there? What are they doing? And how are they adding to Ukraine's case? Having said that, though, the other thing about the interventions that's interesting is that they are very, very similar, which suggests a certain amount of background cooperation which is going on between the states. We're talking, cut and pasting of relatively obscure citations, that sort of thing, very, very similar. So there's obviously been a little bit of background cooperation. And as I mentioned earlier, I think part of the reason for this is that the states are not necessarily there in their own interest to offer their own interpretation of the Genocide Convention. What they're there to do is act as a collective and stand alongside Ukraine in this performance of solidarity at the International Court. As for the case overall, what is the role of the case in respect of the conflict? I think it's very narrow for two reasons. One is that the case is going to take a very long time to reach the merits. We've got preliminary objections. We may have to have another separate round on the admissibility of these interventions. Merits judgment is many years away. So it's not the case that, and that's assuming Russia would conform with the judgment in any event if it was to go against it. So it's not going to have a dramatic effect of, stopping the war in its tracks. But what it does offer is this theatre of justice, which sounds trite, but is actually really essential. This symbolic clash, which offers Ukraine a chance to really mobilise strategic political outcomes, which the interventions themselves demonstrate has already been a success. So I think for that reason, the case is actually very important, even if its tangible outcomes are not necessarily so obvious. I'm not sure how long I've gone on for, so I'll stop there, but I can answer questions.
Thank you, Juliet, for your interesting personal reading of one of the two cases, right, that are pending before the International Court of Justice and which involve Ukraine via Russian Federation. And we might have chance to also touch upon the other pending case since 2017, which involves two different conventions, namely the Convention on the Financing of Terrorism and that on the elimination of all forms of racial discrimination, which we might see the end of day much faster, just to pick up on what you were saying earlier. So without further ado, I would like to now switch to Guyane. And there is some sort of temporal, at least, aspect, which is quite alike what happened at the ICJ with the allegations of genocide case, is that Ukraine was able to file yet another interstate application just days after the beginning of the full-scale aggression. That being said, it already had in the box quite a few interstate applications pending. And so Guyane, without further ado, the floor is yours.
Yeah, thank you, Vlad. Actually, the latest interstate application filed by Ukraine was filed by Ukraine against Russia on 28th of February, so 4 days after the start of full-scale invasion. But I will begin by saying that, of course, the European Court of Human Rights is a mechanism that is used usually by the individuals for the protection of the rights that are guaranteed in the European Convention on Human Rights. And we see now that there are around 8,000 individual applications pending before the court in connection with the war between Ukraine and Russia. And these applications are pending either against Russia, Ukraine, or both states. But since 2014, since the start of the war, Ukraine has lodged 10 interstate applications against Russia, and now they are grouped in 4 different cases. And the first one is related to the situation in Crimea. And that case was lodged. That was the first case that was lodged. And Ukraine is alleging that there is administrative practice of human rights violations. And administrative practice basically refers to widespread systematic practice of human rights violations, which is tolerated by the local authorities of the respondent state. And in the situation of Crimea, Ukraine says that there is a widespread and systematic practice of enforced disappearances, ill treatment, arbitrary detention, persecution of members of a Crimean Tatar community, suppression of non-Russian journalists, suppression of expression of Ukrainian identity, Ukrainian language, etc. And none of these cases, I must say, have been actually resolved on the merits by the European Court, but there are some important admissibility decisions that have been delivered by the court. So in this case relating to Crimea, for example, the court delivered its admissibility decision in 2021, so 2 years ago. And the court said that the claims brought by Ukraine were not manifestly unfounded, so most of them were declared admissible. And an important issue that the court resolved there was that actually Russia exercised its jurisdiction over the territory of Crimea because it exercised effective control through the presence of its military in Crimea. And as the result, Russia was bound to respect the obligations under the European Convention with regard to people who fall within its jurisdiction and who reside in the territory of Crimea. And that's an important finding because here Russia was claiming that they were exercising territorial jurisdiction starting from 18th of March 2014. And 18th of March is the date of the so-called referendum, as a result of which Crimea was declared part of Russia. But the European Court of Human Rights said, no, actually, Crimea is the territory of Ukraine under international law, and you are exercising extraterritorial jurisdiction on the basis of effective control. This is not territorial jurisdiction because this territory doesn't belong to you under international law. And I think that's an interesting aspect of this decision because it's not the jurisdiction and the competence of the European Court to decide territorial disputes or conflicts, but because the court needed to pronounce on the jurisdictional issue, on the application of the Convention to actions of Russia, it had to also touch on this issue. And I think that decision was actually considered by Ukraine an important victory because it's reaffirmed again that Russia's action in regard to occupation and annexation of Crimea were in breach of international law. The other case relates to systematic and widespread violations of human rights in the eastern regions of Ukraine, in so-called Donbass. And this case was also lodged in 2014, and it was joined with the application lodged by the Netherlands with regard to the downing of MH17. And this case also has not been resolved on the merits, but just a couple of months ago, in January this year, the court delivered its admissibility decision. And again, I think it was an important decision because for years, since 2014, there has been a lot of unclarity, factual clarity, unclarity. What actually has Russia been doing in eastern Ukraine? What is its role? Do we have really a genuine separatist movements and independent armed groups? Or is it actually, does Russia have much more serious influence there? And I think that decision clarified the issue. It brought a much needed factual clarity, as well as pronouncement on some legal tests and legal standards that were important. So the court, in its quite big decision where the court examined a lot of evidence, said that actually Russia has been supporting these armed groups. Russian forces have been present on the territory of Donbass since April 2014, and Russia has been exercised control over the territory of Donbass since May 2014 because it's financed, trained, provided military assistance, had a political influence over these armed groups. And the court said that it establishes beyond reasonable doubt that the whole separatist operation was actually curated and managed by Russian Federation. So I think this decision was also important in piercing this veil of Russia's narratives, propaganda, and disinformation with regards to what has been going on in eastern Ukraine. Because Russia has been quite overt with regard to Crimea, saying, okay, this is part of our territory, but acting kind of covertly in eastern Ukraine and pushing this narrative about independence and separatist movements in Eastern Ukraine. And another reason why this decision is important and can have an impact on future decisions for future cases in the European Court is that the court clarified its position on the application of the convention in times of war. So many of you may know that in one of its previous cases, Georgia versus Russia, number 2, the court basically said when the states are fighting to establish control over territory, that means that they are not exercising control over the territory. That means that they are not, the convention doesn't apply because they don't have jurisdiction over this territory. And in this decision in Ukraine and Netherlands versus Russia, the court said, well, the fact that the states are fighting and there is active hostilities going on does not exclude the possibility that they may exercise still some kind of control over certain territories or some kind of control over certain individuals. So they distinguish this phase of active hostilities and claims relating to the killing as a result of active fighting from the claims that may relate, for example, to arbitrary detention or torture, which necessarily mean that a state agent is exercising control and authority over the alleged victim. Another reason, which in my opinion made it easier for the court to declare these claims admissible, is availability of the information. And that's the conclusion of the court in relation to its jurisdiction regarding the episode of downing on MH17. So the court said that Russia was exercising control over the territory and over the forces that engaged in this use of surface-to-missile system. The court distinguished this situation from active hostilities and said, well, this kind of firing of the surface-to-missile system can also take place outside armed conflict. But I think the real reason why the court decided to engage in examination of this episode is the availability of information. And the court actually referred to the findings of joint investigating team on this episode and said that it's established beyond reasonable doubt what happened, who had control, who fired the system, etc. And I think the availability of the information allows the court to piece this fog of war, and that will have an impact on the examination, in my opinion, of this latest application before the court. So the latest application that was lodged by Ukraine in relation to damage and injuries caused by ongoing full-scale invasion. Here, the court will also have to consider in what situations Russia is actually exercising control over the territories of Ukraine or the potential victims, and as well take into account the documentation evidence that are available in relation to the alleged injuries. But this case is limited in terms of temporal jurisdiction because Russia ceased to be bound by the convention on the 16th of September 2022. So this latest application relating to full-scale invasion will relate only to the alleged violations that took place before that date. Thank you.
Thank you, Gayan, for a very informative overview of what's happening at the European Court of Human Rights, and of course a massive procedural hurdle as to knowing what will happen to not just the interstate applications which have been joined in the interests of procedural economy, but also to hundreds of individual against the state applications which are pending in relation to the conflict, particularly now that Russia is no longer a member of the European Convention on Human Rights. So as you start seeing, we are really looking at various branches of international law and various disputes. So now we're going to travel from human rights towards another very important branch, which is questions relating to trade. And I would invite Vitaly to shed light on some of the very important disputes that have been brought before the WTO dispute settlement body. Thank you.
Yes, to everyone. Thank you, Vlad and Chad, for inviting me to speak at this very interesting event. Before I start my presentation, I have to make a brief disclaimer that, of course, everything I say here is my personal opinion and shouldn't be attributed to my International Organization, the Advisory Center on WTO law. I would like to share, I have a few slides for illustrative purposes. I would like to share this with everyone. Great. So I understand that my task today is to explain WTO disputes involving Ukraine in the context of the ongoing war and the general question of today's topic of how judicial decisions can promote justice and peace. It appears useful to start with a few introductory remarks on how WTO addresses the subject of peace and friendly relations among nations. One of the fundamental objectives of the WTO and its predecessor, the GATT 1947, has been to promote peace through trade. So this objective, for example, was included in the Atlantic Charter, which during the World War II served as an inspiration for the post-war multilateral trade system. This objective was also included in the Havana Charter of the International Trade Organization, which was the predecessor or the prototype of the World Trade Organization. Now, as far as the WTO dispute settlement body is concerned, WTO panels and the appellate body do not deal directly with the subject of peace. The mandate is set out in the WTO dispute settlement understanding, and it is simply to clarify WTO covered agreements which regulate trade. In the WTO's judicial context, the issue of peace and high politics more generally fall within the realm of WTO members' policy space, which is guarded by several national security exceptions, such as, for example, Article 21 of the GATT 1994, Article 14 bis of the GATT of the General Agreement on Trade and Services, and Article 73 of the Agreement on Trade-related aspects of intellectual property rights. So in other words, a member may decide to enforce peace, for example, or a principle of the United Nations Charter, such as the prohibition of use of force, through the application of economic sanctions. And the job of the WTO adjudicators here would be simply to determine whether the sanctions are consistent with the legal standard under the relevant national security exceptions. So this legal standard under Article 21, for example, of the GATT has been recently clarified by several WTO panels, including in one adopted panel report in the dispute between Russia and Ukraine, Russia traffic in transit. So this is now one adopted panel report that clarifies this provision. Now, this dispute concerned various transit restrictions that Russia imposed on Ukraine's goods destined for Kazakhstan following Russia's military intervention into Ukraine's Crimea. And this was the first panel report that clarified the legal standard under Article 21. The report was adopted in April 2019. So I would like to say a few words about this legal standard, which was subsequently upheld by several other WTO panels, which you can see on the slide. So all the panels that ruled on Article 21, they concluded that WTO national security exceptions are not self-judging, in the sense that it is a WTO panel and not the regulating member that decides whether this exception applies. So this, for example, was the position of Russia and the United States as well in some of these disputes, including in Russia traffic in transit. Now, for a measure to be justified under Article 21, three elements must be assessed. The first element is that there must be a war or an emergency in international relations, which should be established as a factual issue in an objective manner. As long as this fact is established, the regulating member has a wide margin of discretion in determining, for example, an action that it wishes to take, or rather that it considers necessary to take in response to this emergency or in response to the war. The regulating member also has a wide margin of discretion in determining its essential security interests that arise out of the war or emergency in international relations. So there are two important caveats here. First, the essential security interests must be articulated, And second, there must be a plausible connection between all these three elements. In Russia traffic in transit, the panel found that at least as of March 2013, there was an emergency in international relations between Russia and Ukraine within the meaning of Article 21 of the GATT. Hence, Russia's transit restrictions were justified under this exception. And as we all know, since then, this emergency has escalated into a full-fledged war between these WTO members. Now, what are the practical implications of these panel findings? They essentially mean that while this war continues, WTO members, including Ukraine, are within their right to apply various economic sanctions against Russia, which may include trade restrictions or even a complete trade prohibition against Russia's goods, for example, or services, as long as these measures respond to either the war or Russia's illegal actions. Now, it is interesting to note that before Russia's full-scale invasion of Ukraine, there were 5 WTO disputes between Russia and Ukraine at different procedural stages, which concern different goods and different services. Some of these disputes responded to Russia's concerned economic sanctions that both Russia and Ukraine applied to each other's trade as of 2014. Some other cases, for example, Ukraine ammonium nitrate, concerned a commercial issue, Ukraine's anti-dumping duties that were applied to this good originated in Russia. Now, after full-scale invasion of Ukraine by Russia, the practical relevance of these disputes, in my view, is significantly diminished because, as you can see on this slide, there is hardly any trade anymore between Russia and Ukraine. And this is because both countries have imposed complete economic embargo against each other trade. So on this note, I will stop, and I look forward to answer any questions that may relate to my subject. Thank you very much.
Thank you for this fascinating overview of the cases. Of course, the conflict has given rise to the very first clarification of what Article 21 is and entails, which has an important, I think, systemic also effect. And to stay within the same realm sort of commerce, and we will move to a slightly different angle, and that is of various disputes which are pending between investors, particularly those that have made investments in Crimea and the Russian Federation. And who better than Sebastian to give us the lay of the land? Sebastian, you have the floor.
Thank you very much, Vlad, and I will try to live up to the expectations you may have. Thank you also to you and Chad for the invitation and to the interest group, of course. It's a privilege to be here. As Vlad just said, I will be, in the next 7 minutes or so, I will be addressing the role of investment tribunals in the Russian invasion, but also prior to that in relation to Crimea. And there is actually quite some jurisprudence already on that matter. The interesting part also, there are actually already final awards where tribunals have adjudicated Russia's actions in Crimea and have found Russia liable under investment treaties to pay compensation to investors. What I would like to do is in my presentation is 2 things. I will address these tribunals and their decisions in relation to Crimea, but would also like to turn then to the full-scale invasion and its implications from the investment protection perspective. And I hope we will then be able to also address that further in the Q&A and the discussion later. But first, turning to the Crimea cases, as many of you will know, there have been by now roughly 10, a bit more than 10 investment arbitrations. The exact numbers, of course, not entirely clear, but a bit more than 10 investment arbitrations dealing with the protection of Ukrainian investments in the end on Crimea against expropriation and harmful acts by the Russian Federation. And as I mentioned earlier, some of these have come to a conclusion. There are at least 3 very prominent decisions. The first one that came to an end is the Everest estate decision, where Russia was ordered to pay more than $150 million in compensation to the investors. And then the 2 bigger ones, one of them became public quite recently, are of course the Yoshad Bank decision, where Russia was ordered to pay beyond $1 billion to the investor, the bank, and the Naftogaz decision, where the award was in the amount of $4.2 billion. 2 questions essentially arise in the Crimea arbitrations and are of quite importance there. The first question is, can BITs be applied to the territory of Crimea in light of the territorial scope that investment treaties have? And I think this is something that runs through all the presentations that we heard today, that all the fora that deal with these disputes are somewhat limited in the exercise of their jurisdiction. And in case of the investment tribunals, I think the territorial angle is the most important one. But tribunals have, all the Crimea tribunals that have so far addressed here and have accepted that based on the effective control that Russia exercises in Crimea, the territorial requirement under the investment treaties is satisfied. So this is the first angle. There are, of course, is quite a variation of ways in which tribunals have in the end voiced their positions on that, but in the end they have all come to the same conclusion, namely to accept jurisdiction. And the second related issue then is the one whether, in particular, the Russia-Ukraine BIT can be applied to purely domestic investments, originally purely domestic investments on the territory of Crimea made by Ukrainian investors. And also in that respect, the jurisprudence so far has been clear in the sense that the tribunals have accepted jurisdiction also in that regard. So we have quite a line of decisions, either decisions on jurisdiction or final awards, where tribunals have ruled in this way. And these decisions then have also subsequently been confirmed in setting aside proceedings, annulment proceedings. So there are court decisions by French courts, although this is still a pending case and this is going a bit back and forth in the French courts, but also by Dutch courts and the Swiss Federal Tribunal that have confirmed the tribunal's awards that upheld jurisdiction. The situation now, turning to the full-scale invasion, is a bit more difficult even there, because in relation to the full-scale invasion, we are not only dealing now with a situation where Russia officially proclaims to have annexed the territory, that officially claims Ukraine to be its own territory, but we also have, essentially from my perspective, 3 distinctive situations that could be addressed from the investment law perspective, and probably from with a variety or with a different degree of success in the end. So we have situations where there is an addition, or there are additional occupied territory. In that regard, we might also then be able to extend the jurisprudence the Crimea tribunals have already established to these currently occupied territories. But then there, of course, there are more areas. There are areas of active hostilities, and there are areas where no Russian forces on the ground are present, but bombardments take place. And the question is, can these also then, from an investment tribunal perspective, be addressed? And I think while the situation in occupied territories is quite similar to the one in Crimea, the situation during active hostilities and bombardments from an investment tribunal perspective might be one that actually exceeds what investment tribunals might be willing to accept in terms of their jurisdiction ratione loci. But these are definitely cases that we will see. So we have already one case where at least a notice of dispute has been filed, and that is the case of the national Ukrainian atomic energy operator that operates the Zaporizhzhia, and excuse me for this pronunciation, nuclear power plant. So there's a first investment case already pending in that respect, and certainly other investment cases will follow. The question is then, of course, also, and this is where I would like to turn back a bit to the Crimea cases also. The question is then not also, can tribunals accept jurisdiction in these cases? Will they hold Russia liable? But there is a subsequent issue of the enforcement of these decisions. And also there we have already seen that tribunal awards in relation to Crimea at least have been enforced. The Everest Estate Award is one example where it was at least in part enforced in Ukraine. which however then led to an immediate reaction by the Russian bank against which the enforcement took place, that filed on its own an investment claim against Ukraine to block the enforcement of the award. And of course, Russia itself can. So the question is then, also in light of a race of different debtors that will try to enforce and collect money against Russia right now, how effective enforcement can be. Still and overall, I would say that investment arbitration under these circumstances, and also in light of the fact that it has been quite expedient now, can serve as an enforcement mechanism also of a broader sense in terms of the international rule of law, and private investors can take up this mechanism to also participate in the enforcement of the international rule of law. After all, it's also a strategy that Ukraine actively pursues itself. There's a strategy of lawfare that also involves investment claims. And so investment arbitration certainly can play a role there as well. I think I should stop at this point, and I'm happy to continue the discussion later then.
Thank you, Sebastian. It's just like we're starting to see a bit of the picture as to one of the fundamental issues, obviously, concerning the territorial sovereignty, which seems to be completely on the periphery of some of these dispute settlement mechanisms, but in some cases, it's really at the very core, at least of the incidental, as an incidental question, as an incidental issue, which is necessary for the tribunal then to pronounce on other claims. And so with that sort of leeway, I will now like to invite Nilufer, because precisely in the context of the law of the sea and the two disputes that are pending in arbitration, we have seen a bit of this tension between what are the limits of the jurisdiction, which is a narrow jurisdiction of the UNCLOS dispute settlement mechanisms, and yet how have the tribunals balanced and resisted getting involved in issues which would go into questions of territorial sovereignty. So I think, Nilufer, the floor is yours.
Thank you. Greetings to everyone from Geneva. And thank you so much, Vlad and Chad and the interest group, for inviting me to this really interesting and important event that you're hosting. So yeah, it's almost like, where do I start from? But I think it's important to give these two cases a little bit of context because they involve the Crimea. And I know much of the world now is focused, of course, on the invasion by Russia of Ukraine that took place in 2022, last February. But we have to recall that this was preceded by an annexation, an unlawful annexation by Russia in 2014 of Crimea. And just to give a little bit more background, not everyone may be familiar with the history, but in 1991, after the dissolution of the former Soviet Union, there were the Belozova Accords that recognized the territorial integrity and viability of borders within what was the Commonwealth, and that included Ukraine, which included the Crimea. But as many of you know, I'm sure, in 2014, Russia basically staged a referendum for what laid the basis for this autonomous Republic of Crimea. After 2014, General Assembly adopted a resolution, and this is important, and I hope to get to this a little bit more later on the territorial integrity of Ukraine, that did not recognize that referendum, and also called upon states, international organizations, specialized agency not to recognize this autonomous Republic of Crimea. All right, so what happened? Well, Ukraine in 2016 brought a case under Part 15 of the Law of the Sea Convention, to which both Ukraine and Russia are parties, and it's a compulsory dispute settlement provision, so consent has already been given. Can you hear background noise? Is it okay? Okay, all right. So consent was already given, so that's why Ukraine was able to bring this case against Russia, although Russia did not appear, I have to say, in these cases. So the dispute was brought before the arbitral tribunal. I'm not going to go into the details why. And essentially, we call it in short the coastal state rights case. And in this, essentially based on the Law of the Sea Convention, so the rights of Ukraine as the coastal state, alleging basically that Russia was interfering with these rights, and to have recognized Ukraine as having exclusive rights to engage, for example, in exploration, exploitation of natural resources, fishing activities, protection of the environment. I won't go on, but it's a very long list. And also, Ukraine also wanted to recognize its right of passage through the Kerch Strait, also alleged that Russia had violated its obligation of cooperation by this unlawful construction of a bridge in the Kerch Strait. And there was also questions about the status of the Azov Sea, whether they were internal waters. So a whole slew of cases. Of course, without surprise, Russia challenged the jurisdiction on this, and the grounds that this was essentially a conflict, a dispute over sovereignty, and sovereignty is excluded from the purview of the Law of the Sea Convention, unless it's ancillary and not the main issue. And I think this is the critical part. Also, Russia claimed that the tribunal didn't have jurisdiction because it had exempted, which you can under the convention, certain activities from compulsory dispute resolution, such as military activities and law enforcement, which is what Russia claimed it was doing. It also claimed that as to fisheries, that both had, when they had ratified the convention, had opted for what's called an Annex 8 special tribunal, special chambers for that, and therefore, again, the tribunal didn't have jurisdiction. So all these jurisdictional issues. But ultimately, the big issue was whether this case was about a sovereignty dispute over Crimea. And of course, I mean, that was obviously the big issue. So what the tribunal did, I always thought was very interesting. So on the one hand, the tribunal did uphold Russia's objection that it lacked jurisdiction over Ukraine's claims to the extent that the ruling of the tribunal on the merits would require it to decide directly or implicitly on the sovereignty of either party over Crimea. However, it did reject the other objections to jurisdiction by Russia. But, and this is, it gave Ukraine a hook. It said, Ukraine, please file a revised version of your memorial to take into account these concerns and basically bring it back to address the issues concerning where it did find there was a problem of jurisdiction. Beforehand, because there's also another case that was brought regarding actions by Russia in 2018, basically shooting at 3 Ukrainian naval vessels that were exercising what Ukraine felt was its right of navigation in the Kerch Strait, and essentially arrested those vessels and the 23 naval persons. So again, Ukraine, using the compulsory dispute settlement mechanism under the convention, brought a case on the merits under Annex 7, but also a case directly to the tribunal in Hamburg for provisional measures to have the vessels released, as well as the naval servicemen, and which was granted. And what is interesting is that I did look, and Russia indeed did release the naval vessels and return them. Now, since then, these cases have remained frozen, but something important has happened, and because we're running out of time, maybe in the Q&A we can get to this. I would like to make a linkage to developments that happen in relation to Mauritius, Chagos, and a very interesting case that is also pending before the ITLO's special chambers that was brought by Mauritius against Maldives for maritime delimitation. And so I'll leave it at that, but I will come back to that in the Q&A because I do think that there may be an interesting opening on this question of jurisdiction and whether indeed the tribunal really does lack jurisdiction because of it being a dispute over sovereignty. So I'll stop right there.
Thank you, Nilofer. Indeed, we will probably try to return to that during the question and answer. To which now I pass the floor as a moderator to Chad, so that we can kind of go into more like direct question and answers to our speakers. But we have now covered the lay of the land, so hopefully our audience now can see the variety of disputes and variety of underlying issues covered by some of these dispute settlement mechanisms. So Chad, please.
Thank you very much, Vlad. So what we'll do in the Q&A is I'll first ask some questions to individual panelists, and then we'll have some general questions for all panelists who can answer as they see fit. And I'll start, as we started, in order with Juliet. And Juliet, you were talking about the theater of justice in the allegations of genocide case and the importance of having a judicial decision, even if it may be years away, that may end up supporting Ukraine's arguments regarding the Genocide Convention against Russia. And given that the court's decision is going to take a few years, if the conflict is going on still at that point, what effects do you think the judgment might have? And might the judgment cause third states, such as India or China, for example, to reduce cooperation with Russia?
Thanks so much, Chad. Yeah, so I'm going to hijack your question ever so slightly to talk about the financing terrorism case for just a very brief moment, because what that case shows us partly is how long these things can take. So that case was filed in 2017. It's now 2023, and we're only at the rejoinder and counter memorial stage. So we're still at least 12 to 18 months away from a judgment in that case. So it gives you a sense of just how long these decisions can take. In terms of, what is the effective outcome? I mean, I've already mentioned the symbolism and how that is actually an important and tangible measure in these relationships between states. But in the longer term, especially the allegations of genocide case, where Russia has sort of creatively reworked the humanitarian intervention doctrine, we will see a legal outcome that will probably say something rather clearly along the lines of, no, you can't go around invading other states in order to prevent genocide. So that will create, from kind of global rule of law perspective, some real clarity on the potential scope of these kinds of doctrines, and obviously, possibly present a rejection of Russia's version of that doctrine. And in respect of the kind of border aggression things, this case and the financing terrorism case will not rule on really the big issues, the question of the legality of the aggression, the question of the legality of the annexation of Crimea. But the court will probably say tangential things about these issues because they can't really avoid the broader context in which these disputes have been brought before the court. But it will say as little as possible because the court doesn't like to go on and on. So in that respect, are those potential decisions going to have on third states? I think that the best you can really hope for is it reduces the potential for sitting on the fence, if you will, or for plausible deniability. For states like India and China, it makes it a lot harder to sort of say, look, this is not our fight. This is not something we need to get involved in. We're going to take a position of neutrality here, because the court has ruled very clearly on the scope, the legal scope, and it's drawn a line in the sand, said, you know, this is legal, this is illegal. So in respect of broader political negotiations and interstate relations, the judgment has quite substantive effects there. So whether these are going to be, as I said, they're going to be a long time coming, though. The states that have already sort of sided with Ukraine, they've made their position very clear through the interventions in the genocide case. As for the other decisions, I think states will tend to sit back and kind of wait to see what the court says, knowing that it will take a long time. So they're kind of safe for a few years there. I hope that answers the question.
Indeed, thank you. And it's interesting to see, you know, the length of time that ICJ decisions have, and the implications of that. I know in the Black Sea decision that discussed maritime delimitation between Romania and Ukraine, shortly after that was decided, Crimea was annexed, and so the decision became a bit of a moot point from that perspective, because Ukraine no longer had control over Crimea and the maritime areas around it. Turning to Guyane, you mentioned the number of interstate cases against Russia in the European Court of Human Rights, including the case of Ukraine and Netherlands v. Russia, talking about the downing of Malaysia Airlines Flight 17, among other items in that case. And there have been cases including the alleged abduction of children and their transfer to Russia from the Donbass regions in 2014. And so I was wondering, to what extent could the evidence presented in these judgments be used in criminal cases eventually against Putin or other Russian citizens? And is there any precedent for evidence in the European Court of Human Rights being used in criminal proceedings before other international courts and tribunals?
Well, international criminal courts and tribunals often refer to the jurisprudence of the European Court of Human Rights, but not for evidential reasons, rather because of the standards relating to fair trial and due process. And in my opinion, I think it would rather be the opposite, that the European Court of Human Rights would be using the evidence that were collected in the course of the criminal investigations by different bodies. And we saw that also in the admissibility decision in the case that you mentioned, Ukraine and Netherlands versus Russia, because there the court referred to the findings of joint investigation teams set up by different states. And that was a useful instrument, a useful source for the court, and the reason why the court was actually prepared to go into examination of these issues. And I think because criminal investigations take place on the spot and they aim to establish the individual criminal responsibility, they will be they use the instruments that the European Court of Human Rights doesn't have, sitting in Strasbourg, doesn't do any more fact-finding missions, etc. But that said, I think the examination of the totality of the evidence by the European Court of Human Rights can feed back into the proceedings before the international criminal courts, especially in respect with the questions related to the context and contextual elements of international crimes. For example, establishing that there is indeed an international armed conflict pending or at least before the full-scale invasion was pending in eastern Ukraine. So I think there will be certain, of course, interaction in terms of use of evidence and interplay of jurisprudence between the European Court of Human Rights and criminal courts and tribunals.
Thank you, Guyane. And it'll be interesting to see as we move forward the implications of decisions by certain courts and tribunals on the proceedings in other courts. There's so much interplay going on right now between the various courts and tribunals, both on the civil and criminal side. And I think that's going to be really interesting to watch going forward. I'm going to move to Vitaly now. you were talking about the national security exception clause, and how it's not self-judging on the one hand, but on the other hand, how states have broad ability to define what their own national security interests are. And in the measures concerning traffic and transit case, I believe that the panel accepted that Russia's own actions, including its annexation of Crimea, were the actions that created the emergency. And so the question is there a danger that this national security interests, essential security interests clause will allow states to effectively create their own emergencies and allow the state to deviate from WTO trade practices based on emergencies that they themselves have created?
Thank you very much for this question. Just a small clarification here. So the panel found that the emergency existed as a matter of fact from a particular time period, 2014. The panel did not decide on the issue of who created the emergency. And in fact, the panel specifically stated in that report that it was not necessary for its analysis of the consistency of Russia's measure with Article 21 to decide which party created the emergency or was responsible for the emergency. So essentially, so your question essentially addressed, can be slightly sort of reformulated in this way. Can a member responsible for an emergency then avail, or should a member responsible for the emergency should be able to avail itself of a national security exception? So this is the question of basic fairness here. Now, so the panel touched upon this issue and it said and it stated that it was not necessary to rule on that. As a WTO lawyer and WTO practitioner, I agree with the panel's approach for this very basic two reasons. So first of all, under Article 21, as I mentioned, the existence of an emergency is a factual issue. So I don't see any textual hook for the WTO panel to rule on this broader question of which party, for instance, which WTO member violated international law and created an emergency. So this is sort of the question of that sort of a slightly remote from typical issues on which WTO panels rule. Now, the second reason is that even if we were to look for the basis to rule on this issue outside of Article 21, for example, general international law, the principle of good faith, as I explained earlier, as we discussed earlier, WTO panels, they have a very narrow mandate to rule merely on the consistency of a trade measure with WTO covered agreements. So one could question here whether panels have any jurisdictional authority to decide on such complex matters as whether a particular member violated international law, for example, some principles of the UN Charter. And here I would also question whether WTO panels and the WTO Secretariat that assists WTO panels even have sufficient competence to assess such complex issues. So that's why in the WTO legal framework, the issue of the existence of an emergency or the existence of war is really approached from a factual perspective, whether it exists or doesn't exist, and if it exists, whether this triggers the application of Article 21.
Thank you, Vitaly. That's very helpful. And turning to Sebastian, on the question of arbitration, we've seen, as you said, many awards against Russia coming out of the Crimea cases. Some awards over $4 billion in the Naftogaz award and billions of dollars or hundreds of millions in others. And the question I had was, how easy will it be for investors to enforce these awards against Russia, in particular against frozen Russian state assets, such as assets of Russia's central bank that have now been frozen in in many countries around the world. And have any claimants been successful in enforcing awards in these Crimea cases to date?
Yes, thank you very much for this question, Chad. Maybe taking the last angle that you took first. So yes, there has been at least in part successful enforcement, or by far not of the total award, but only of part of it. So this is one aspect to it. Awards have been enforced, but most of the enforcement proceedings currently are pending. So in the United States, for instance, you have currently pending enforcement proceedings for various awards, including the 1.1 or 1.3. I think the figure is not entirely clear there. Oshad Bank Award. There's currently an attempt to enforce this in the US. We will need to see how this plays out, and it will certainly be a difficult issue. In relation to the frozen assets, I think this will, to a large extent, also depend on the interaction of the enforcement procedures with the sanctions regimes. So, for instance, in the European Union, when the EU first adopted a new sanctions package, the way the frozen assets were available for enforcement of arbitral awards was that the EU had limited the enforcement into these assets to awards arising out of or rendered in that had already been commenced before the adoption of the sanctions. So there was a certain time limitation, which would have limited the enforcement of awards to enforcement of awards of already pending proceedings at the time, not of awards arising out of, so to speak, fresh proceedings, new proceedings started after the spring 2022. And of course, in relation to the frozen central bank accounts, you have the tricky issue then of immunity of these accounts, which would need to be addressed and will be addressed then from the courts in different angles. I think there potentially the prospects of enforcement in the US might be somewhat greater than in the European Union, where the handling of designating states, in particular Russia in that regard, as a state sponsor of terrorism, for instance, is different. So we don't have such mechanisms in the EU at present, whereas there might be easier than other places.
Thanks, Sebastian. And it'll be interesting going forward to see what success claimants have in getting some of those frozen Russian assets, and as a result of the enforcement of these awards. Niloufar, you were discussing the coastal states' rights case and the fact that the tribunal found that it had no jurisdiction over Ukraine's claims to the extent that it would decide explicitly or implicitly on the sovereignty of the territory of Crimea. And I wanted to ask, what does that leave to be decided on the merits at this point? And could the resolution of any of those issues perhaps result in clarity when the conflicts end over the area around the Sea of Azov and the Kerch Strait?
Yeah, thank you. So I had mentioned as I was ending some interesting developments that we can look into concerning the Chagos case. And back, I guess, in 2010, around there, time goes quite quickly, Mauritius had brought a case under Annex 7 against United Kingdom for establishing a marine protected area. And one of the issues that Mauritius had raised was that the United Kingdom was not the coastal state, because there was obviously a dispute over the decolonization process and the sovereignty over the Chagos Islands, and therefore it was not lawfully having competence to establish that marine protected area, because this is under the law of the sea convention. Other issues as well, but in that case, the tribunal, similar to the tribunal in the Ukraine case, decided that the main issue was not a question of the interpretation or application of the convention, but in fact had to do with a dispute over sovereignty. Now let's fast forward some years. Much has happened since that decision. There was a very interesting ICJ advisory opinion on the lawfulness or the unlawfulness of the decolonization process of Chagos from the UK, which the opinion said was unlawful, and that Chagos was part of the territorial integrity of Mauritius. So, and then a General Assembly resolution was passed. Then Mauritius brought a case for maritime delimitation that, of course, involved the Chagos area against Maldives. And Maldives raised the issue that this is a dispute over sovereignty. The previous tribunal, Annex 7 tribunal, rejected jurisdiction on this point. But this time, the tribunal was actually special chambers of the tribunal, took a very different approach and said, well, that was then, this is now. I'm paraphrasing, of course. And why? Because now we have resolutions, we have advisory opinion, recognizing the unlawfulness of the decolonization, and that Chagos was part of the territorial integrity of Mauritius. So I think that there's some important clues here. And that's why I did highlight the resolution. And I won't go into, use Kogan's and all this, but perhaps the tribunal needs to reconsider. And since now we've had the invasion, the idea of characterizing as a dispute something that is unlawful, and accepting the fact that Ukraine would be the coastal state because it is against the territorial integrity of Ukraine. So I'm just raising the question because I think it's interesting that the Chagos situation has definitely, to me, that was a fascinating decision by the special chambers of the tribunal. Secondly, and I don't want to dwell too much longer, take up time, but another very interesting case with the South China Sea Arbitral Award. Same thing. The dispute over the sovereignty of the islands was the position that China indirectly took through its white paper. But in that case, the tribunal said, well, sovereignty aside, we're looking at protection of the marine environment issues or the status of offshore features, which are independent of sovereignty. So again, there may be elements, particularly on the environmental issues and the challenges made to Russia that do not entail determining a coastal state, who is a coastal state, that the tribunal could address because they do stand alone independent of that. So there are clues in other cases, and I'll just stop there.
Thank you very much, Niloufer. And given the time, I'll just pose one general question to all our panelists, and then we'll go ahead and move on to questions from the audience. And that is this. I'm going to get back to the central theme of this panel, which is the conflict and tension between providing justice to parties in the case at issue and reaching outcomes that may help promote an effective resolution to the conflict. And how have the courts and tribunals in your cases balanced those two considerations, and should courts and tribunals consider as a factor in their decisions the possibility of a result that could help promote the resolution to the conflict, or should they decide cases strictly based on the law, even if reaching a certain result could potentially aggravate the conflict? And I'll take hands. Juliet, go ahead.
Yes, well, look, I think It's interesting because it depends a little bit on how you classify this idea of resolving a dispute, which is the court's kind of key task. On the one hand, some people would suggest that the dispute is the purely legal question. So in the ICJ's cases, the application of the CERD or Convention Against Financing of Terrorism, or this question of the interpretation of the Genocide Convention, and that they can stick to that. But the reality is the courts also have a really important social governance function. And that function encompasses this idea of resolving disputes in broader contexts. Now, that's not to say that the court ought to take external factors into account, but it can't ignore them either, and it can't sort of pretend that these cases aren't arising in a particular context which involves unlawful aggression and so on. But I think, the important thing is where you've got cases that might be perceived as being brought sort of an ulterior purpose, and Nilofer was sort of talking about that with the Chagos case. It's not up to the court, really, I think, to characterize the dispute. The court has to deal with what it's given by the parties, but it can't ignore its social governance function, and it can't sort of just pretend that doesn't exist either. I know that's a very, very, I'm trying to have it both ways kind of an answer, but that's sort of that's my opinion.
No, and sometimes it is a both ways type of issue. I think that there's a balance to be had, and if you can try to address both of those at the same time, so much the better. Gayan, you had your hand up.
Yeah, thank you. After the International Criminal Court issued the arrest warrant for Putin, I don't think any other international judicial mechanism can aggravate this any further. And to be honest, I don't think at all the aggravation of the conflict depends on what international courts do, because the conflict is already so serious, and Russia does not really care about international law in this situation. So to me, the function of international courts and tribunals is very important here in maintaining the legitimacy of the system, restoring the violated rights, and when we are talking about European Convention on Human Rights, restoring the rights of the individuals, which is important for restoring of the peace and the situation that existed before the war broke out. But I also have quite a realistic perspective on the situation. In that sense, I think that what will help negotiation and settlement of the conflict in these situations is actually strengthening Ukraine militarily. And not a particular decision of the international courts in this situation, unfortunately.
Thank you, Gayan. Sebastian, go ahead.
Yeah, maybe to just give a bit of a different view also, at least how I would believe that the investment tribunals approach this. And this probably also relates to the fact that they, of course, are ad hoc tribunals that have been constituted for the particular cases, and already on that basis don't necessarily see themselves as part of a broader system, or at least many arbitrators don't see themselves as part of this broader system, apart from maybe contributing to constant jurisprudence within the investment arbitration system. So I would think, at least for the investment arbitration tribunals, their understanding of the mission in the Crimea cases, potentially also in future cases relating to the invasion, would rather be really a case-centered understanding, and an understanding that at least not as much as the ICJ, for instance, or the European Court of Human Rights would take into account the external factors and the broader conflict. Coincidentally, however, this might still lead to a result, as we might agree, that is contributing to at least a certain degree of pressure on Russia, a certain degree of monetary pressure on Russia. But I would not believe that investment arbitral tribunals would take these considerations too much into account, but their mission rather, as they perceive, is probably to decide the dispute before them on the basis of the law, and go ahead like this.
Thanks, Vitaly.
Thank you very much. So in the WTO context, it is in fact one of the duties of the panels and the appellate body to assist the parties in resolving the dispute, while focusing, of course, on the specific issues that are raised in each given dispute. So the panel report on Russia traffic in transit is actually very interesting from this perspective, because while the panel, of course, had to rule directly on what kind of trade measures Russia could take against the goods originated in Ukraine, the panel indirectly clarified what trade measures Ukraine and its allies also could take against the goods originated in Russia, while the emergency and now the war exists between Russia and Ukraine. So in other words, there is an emergency, or the war is a factual matter, but the war cannot exist only, it is not a one-sided issue. This emergency always exists in international relations between several parties. And here we have Russia on one part, and we have Ukraine and its allies on the other part. So in this sense, I think this panel report is very helpful, because it really indicates that the economic sanctions that both Ukraine, the EU, and the US, Canada, all the other members that they apply to Russia, they are lawful within the meaning of WTO law.
Thanks very much, Vitaly. Given the time, I think it would be best to move on to questions from the audience. So thank you all very much for this interesting discussion, and I will pass the floor over to Vlad again to pose some questions from the audience. Thanks very much.
In fact, Chad, I would have to ask you, because unfortunately I was disconnected. There was some sort of glitch, and suddenly all of my questions disappeared from the screen, so I'm not able to see them. So perhaps you can go ahead with one or two questions from the audience, and then.
Well, sure. I will go ahead and pose some questions then in the question and answer. We had a question for Guyane. What happens with the ECTHR cases now that Russia is no longer in the Council of Europe? And is Russia responding to any of these ECTHR cases?
So the European Court of Human Rights continues examining cases that relate to the alleged violations that took place before 16th of September 2022, so the date when Russia stopped being party to the European Convention. And the court clearly has already said in some of the decisions that Russia is responsible for complying with the convention before that date and for cooperating with the court in relation to the cases relating to that situation. The court also has said that the fact that Russia is not appearing before the court and is not cooperating with the court actually means that Russia has waived its right to appear before the court, but that is actually consistent with the adjudication or administration of justice, because the waiver was voluntary in a way and without good cause on the part of from Russia's side. So the cases continue to be examined by the court. The court has also decided to appoint a judge in respect of Russia from the judges sitting on the court, so an ad hoc court from among the judges. And the court has actually delivered also an interstate, a decision in the interstate case, Georgia versus Russia, #2, on just satisfaction just last week, without Russia's participation in these proceedings. Much more problematic issue is, of course, enforceability of these decisions. And in this respect, Russia is not cooperating with the court either. So I think in general, the enforceability of interstate cases is quite a problematic issue before the court, and it not only relates to Russia. For example, in 2014, the court delivered a decision on just satisfaction in the case of Cyprus versus Turkey, where there was a very big award made as well, but that decision remains unenforced as well. So actually enforceability does not necessarily relate to the fact that Russia is no longer part of the convention system, but just because of the nature of these proceedings, interstate disputes, and the very high awards, financial awards that are made by the court in this situation. And my last point is just would be that in the convention system, the just satisfaction consists not only in the compensation, actually the declaration that there was a violation and finding that there was a violation can in and of itself amount to just satisfaction, or is a significant part of the just satisfaction in the system of the European Convention on Human Rights. And in that it can be valued, its value lies in that as well, and that does not require actually any action on the part of the respondent government.
Thanks very much, Gayan. We have another question. Says that Russia has disrespected international law on a vast scale, but do we really think that Russia does not care about international law at all? And if that's the case, why has Russia taken certain steps to create a legal pretext for its actions, such as the sham referendum in Crimea, or the argument when it began the invasion that it was just preventing genocide and acting in accordance with its obligations under the Genocide Convention?
Yeah, very good question. Thank you for that. I think it's a paradox and a duality in Russia's attitude to law, because on the one hand, Russia engages in the law in the sense that it wants to give the veneer of legality to its own actions. And we see these reforms, domestic reforms in the constitution, then seek to justify Russia's actions, and also the resort to various international law arguments when it's actually acting in breach of international law. So in that sense, Russia wants for the world to see that that its actions are lawful. And it's also a part of its narrative created for the domestic audience to see that to show that we are purportedly on the right side of the law. But in reality, I think Russia's actions and disregard and everything that they have been doing, at least in Ukraine since 2014, in Georgia in 2008, and even early in Chechnya, actually shows that in substance, Russia does not respect international law.
And maybe I would pose the same question to Juliet in terms of the ICJ cases. Russia is a participant in those cases. So to what extent do you think Russia really cares about the outcome of the ICJ cases? Given their lack of respect for international law, do they really think that the ICJ cases will make a difference, or is there something in it for them to appear before the ICJ and defend themselves?
Yeah, look, I think Gayan has sort of hit most of the points directly on the head, but in respect of the ICJ in particular, I think that Russia perceives the ICJ as a useful forum for it to continue a sort of battle for legal hegemony between Russia and the West, like its version of the way that the world ought to be ordered legally. And so the court is a useful forum for voicing that and gaining some traction, both domestically and with whichever allies it can sort of muster. But it sort of, I think, ties into this particular worldview of, I guess, righteousness of their own perspective on the way that they're doing things. So it's not so much, clearly, their version of international law is not the version of international law that represents reality in a lot of ways. It's not the agreed version. But nevertheless, I think they do perceive some value in sort of trying to fight for their kind of point of view, at least in a place like the court, which is so kind of symbolic for interstate interactions. But otherwise, I think I've just endorsed sort of everything that Gayana has said. She really nailed it.
Great. Well, Given the time, we are drawing to a close. So with that, I will pass it back over to Vlad to deliver some closing remarks and sum up the panel.
So thank you so much. I mean, we would have liked to continue this discussion, but time, of course, is flying. But I think several takeaways from this. First, of course, the diversity of disputes that we have had. And it is quite a unique case going forward. I think it's just from a systemic perspective, we will see whether in the future, in the context of active hostilities, other states will be able to mobilize themselves in such an efficient way as Ukraine has done, in trying nonetheless to seek mechanisms available in international law to settle these disputes. Now, of course, we all in this panel seem to be in agreement that some, or in fact, the majority of these disputes will not necessarily put an end to the active hostilities. But I think collectively, you know, depending again also on the types of awards that will be made in terms of the types of arguments which will be supported and some of the claims which will find their legal validity, overall that may exercise a considerable degree of pressure, I think, on bringing the Russian Federation back to compliance, and perhaps, you know, changing quite entirely the dynamics of, you know, what has been hanging out there as a potentially one day a negotiated settlement for the conflict. And we will see whether that will happen. But I think we definitely are left with a lot of food for thought in terms of what our experts have shared with us today. And I think I couldn't end this panel without making just a few brief remarks about what this actually means to the Ukrainian constituency. You know, we quite often, when we think about international dispute settlement, we tend to forget really some of the grassroots and what it means for the people who actually are subject of an active armed conflict. And I think what, you know, speaking as a Ukrainian, these various dispute settlement proceedings are pretty well known by the layman in the Ukraine. You know, I mean, of course, they don't know the jurisdictional, the enforcement, and the various other aspects concerning the relief that can be obtained. But there is a general awareness that many of these proceedings are underway on an international level. And of course, there is a largely overburdened expectation which is placed on international courts and tribunals, which I think is an assumption which clearly not the right one, probably from an empirical perspective. Yet, I do believe that it's on everybody's mind at the moment to say that the peace and justice kind of going hand in hand and are the ultimate goal of all of the Ukrainian people. And so it is my sincere hope as an international lawyer, as a Ukrainian citizen, and just ultimately as a human being, that these proceedings, either individually or cumulatively, in the short or long term, will go some way towards achieving that goal, and will bring justice and peace together and put an end to these active hostilities. So I really thank you for all your contributions and for letting us leave with a much better understanding in terms of how these dispute settlement mechanisms has thus far contributed to that goal. Thank you so much.